Welcome back, everybody, to another shocking courtroom episode of Lockdown 23 in 1. That's right, and bear with me, ladies and gentlemen, I apologize, I'm still a little congested. Still getting over this cold a little bit, but the show must go on. Today we're traveling back into a Michigan courtroom to witness a 16-year-old. Well, he's 18 now, he's been in jail for the last 2 years, but when he was 16, he recklessly drove into a family, which caused the death of a mother and unfortunately her unborn child. Not to mention the husband who was driving was severely injured as well. So with all that being said, let's get right into it, ladies and gentlemen. If you're new to the channel and enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my beautifully assorted playlist with many more videos for you to start watching today.
Right. Mr. Arvalo, do you wish to say anything on behalf of your client?
Yes, Your Honor, I will allocute, and it's possible, Your Honor, that one family member may also allocute. I'm not going to read a letter. I'm going to let them speak if the court so permits.
Well, that's not normally how that would work. I mean, it's that you would say something on behalf of your client, then your client says something. Not if you want to, I guess, read something from a family member, I'll allow that.
Okay. Your Honor, before I start allocuting for my client, I want the Kanaya family to know that my client and I deeply sympathize and offer our condolences. If we could bring the dead back to life, we would, regardless of the cost. Your Honor presided through the whole jury trial. It was a short trial, Judge, but it brought out two things. In People v. Milbourne, it said the sentence must be proportionate to the offense and the offender. So let's talk about the offense. The offense was fleeing and eluding, Your Honor, which resulted in an accident. So it was an accident, it was not a planned killing. I've seen cases which are much, much more horrible than this on a murder too. But this was an accident. The consequences of this accident were terrible, irreversible. I agree fully. My sympathy and empathy is with the family completely. But nonetheless, we cannot forget this was an accident.
I'm sorry, but almost everything that the attorney just said went in one ear and out the other. I can't help but to look at this guy's filthy demeanor.
Note, Your Honor, when it comes down to an offender, we have to see who the offender is. Travion is a 16-year-old law-abiding kid. He has no prior record whatsoever, not even traffic tickets.
Homeboy ain't 16 right now, okay? When he committed the crime he was, I believe he's been in jail for 2 years. He's 18 now, but, he's looking like a cool 32. And this dude keeps acting like he's messing with his shackles. He ain't doing that. He's fake flexing on the camera. He's been doing them push-ups for 2 years, man. He wants someone to see him. Better get your flex in now, man, because you're about to be smoked for decades if I were to guess.
Of course, he had been driving only 4 months, Judge, so he couldn't have accumulated too many tickets in that. He had his own car as it came out at trial, but he did not drive it because he did not have insurance or registration. He wanted to follow the law. So he drove his cousin's car, and he had no idea that she had not kept the insurance up to date. He wanted to drive a car which had insurance. He was not fleeing because he had drugs in his system. Judge, he was tested immediately with a blood draw. No alcohol, no drugs, nothing. There was no contraband found in the car. He was not fleeing because there was contraband, or guns, or drugs, or dead bodies, or anything of that nature.
Criminal record, just driving, accident or not, it doesn't matter. He killed an innocent, pregnant lady. That's all that matters, and he needs to pay for it today.
It was his irrational fear of the police which caused this accident. As the prosecutor mentioned to me more than once, this is an irrational fear. And that's why we wanted to bring in the additional stuff to show that when you put yourself in his shoes, it is not irrational. He basically gets stressed out, and when he gets stressed out, his anxiety spikes. When his anxiety spikes, he reacts. He does not act. He just reacts. And on that day, he reacted by trying to run away from the officers.
So what kind of message would this give to anybody that has anxiety spikes and just wants to react? To go ahead and do it, it's okay? Nah, man. You gotta teach him a lesson, Your Honor.
Now, talking about the drugs, Judge, Your Honor, Your Honor is well aware of what had happened. There was a previous lawyer, Your Honor, and thereafter I was appointed. And that on that day, Judge, he had come to court. He had come to court, but as I explained to Your Honor, with proof that he had worked all night, and therefore when he came over here, he started to fall asleep. When he fell asleep, the court asked, why is he asleep? And counsel indicated, probably he smoked marijuana. And that was not true. We proved to the court that he was asleep because he basically had worked all night. He came in an Uber, we brought receipts, we brought the stubs checking him, and the court agreed. The court said, okay, I'm going to give him a personal bond. So from that day onwards, he was on a personal bond, despite these charges.
All right, so let me get this right here. He ends up accidentally snatches a pregnant woman in her unborn child's life, goes to court for it, falls asleep during court, and gets a personal bond. I don't know if you should be taking notes on that one, all right? Typically, falling asleep in court doesn't work on your behalf.
He's a normal and good kid who behaves normally and responsibly. Responsibly, until he sees the police. I understand Your Honor has to take into consideration the harm done to the Kinaya family. But that harm was never intended. Travion never bore any malice to the Kinaya family or to anyone else. It could have been anybody who got struck in that accident that day. It could have been he who got struck in an accident that day. It could have been the police who were following him who got struck in an accident that day. There was no malice intended. He was just trying to get away from the police.
It doesn't matter.
Your Honor must also consider the fact that Travion was a growing child when this accident occurred. As the prosecutor repeatedly told the jury during trial and closing arguments, it is not for you to take into consideration that he is very youthful. It is for the judge to take that into consideration at sentencing. And Judge, I'm asking you to do just that. Take that into consideration at sentencing. Certainly, Your Honor can give him a lengthy sentence and throw away the key. But that is not going to result in any rehabilitation. One of the main factors of sentencing, besides the ones indicated by the prosecutor, is rehabilitation. We have to make sure that when he comes out, Judge, he has the ability to take his place back in society. Psychologists, Your Honor, indicate, and that is in the report prepared by the social worker, juveniles often have a problem with risk assessment, assessing the risk of fleeing. And they also have a problem with making proper judgment, which he definitely did not make that day, Your Honor. This is because growing children have developing brains. Once these brains finish developing, these juveniles do not repeat the mistakes that they made as juveniles. Travion thought he could get away that night by speeding from the police. But there was no reason for him to get away. Your Honor, because the guidelines are so high, any sentence, even at the low end of the guidelines, is going to be extremely long. Something which will result in Travion never acquiring the skills necessary to take his place in society. Travion will be middle-aged, Judge, if you go at the low end of the guidelines. He'll be an old man, assuming he lives that long. How old is your client? He's right now just turned 18, Your Honor.
He'll be before he's 40.
The judge said, oh, well, then he'll be out before he's 40. I'm guessing that's probably the maximum time he'd get, whatever that might be. Yeah, he's pretty much saying he'll be just daddy. Look, keep in mind, I went to prison 2 times, and, I wasn't no YouTuber till I was like 28, 30, something like that, middle-aged. What I'm saying is he could easily do a 20 clip, get out and change his life around. I don't know about easily, but, it's possible. And the judge is looking at it like that, too, if I were to guess, judging by his reply. The fact of the matter here is he took a person's life, whether he meant to or not, he's got to pay.
I understand, Judge, the harm done to the Kinaya family. It's irreversible. It's terrible. But imposing a lengthy sentence will not reverse the harm done to them. It will only extend the harm to Travion's family.
What?
We must focus on rehabilitation, despite the tragedy to the Kinayas. Now, Your Honor, as far as deterrence is concerned, I agree with the prosecutor, but he's been charged, Your Honor, for the 4 additional crimes. Although I'm allocating on murder, he's been charged with fleeing and eluding, causing death, and Your Honor is going to sentence him on that. He's been convicted of that serious felony, He's also been charged with fleeing and eluding, causing injury to a person. He's been convicted on that, Your Honor, and we always told the jury that we are acknowledging that. We never shied away from it. Your Honor is going to sentence him on that, and there's going to be deterrence on that. There is then the question of the fetus, Your Honor, which had to be aborted, or rather, which died when Faith Kinaya died. And Your Honor, he has a conviction on that, and that also you're going to sentence him on. And lastly, Judge, as far as the 2-year-old is concerned, he also suffered injuries, and there was a fleeing and eluding, causing serious injuries over there also, and he's got a conviction over there, and Your Honor is going to sentence him on that as well. So after sentencing on all of these for all the 4 people who have suffered harm and loss, we then come to the super umbrella, okay, the super umbrella of the murder 2 charge, okay, and we are asking for the highest end on that charge. Judge, he's being singled out. Okay. Now, Your Honor, if I look at page 4 of the pre-sentence report, where the guidelines were calculated, and the probation officer has done a fantastic job in providing as to why she has scored these guidelines in this way. And she talks about OV 13 not scored pursuant to People versus Carl, CARLL, 322 Mishap 690. And Your Honor, I sat and read the Carl case, and it's virtually, the facts are not only similar but almost identical. This is also a case of gross negligence. Defendant was supposed to stop at a stop sign and let the others who had the ability to go, but he didn't. He in fact went full speed, breaking the stop sign, ran into the other car, killed a person in the other car, and seriously injured somebody else as well.
I would have to stop him right there. Like, why are you breaking all this stuff down again? This is what the prosecution does, bro. I don't want you re-mentioning none of this. I want nothing but sweet nothings mentioned about me. You're fired. Right? I'm not rooting for this guy. I hope he gets smoked from here to kingdom come. But this attorney, I can't help but to think, is just burying him a little deeper and deeper.
Again, had the same thing. Fleeing and eluding, causing death. Fleeing and eluding, causing serious injury. And Your Honor, right at the beginning, on 690, the court indicates the trial court sentenced the defendant to serve concurrent terms of 4 to 15 years for the reckless driving causing death, and 23 months to 5 years for each of the reckless driving causing serious impairment convictions. So, Your Honor, that is what I normally see in these cases. In this county also, Judge, we have a similar situation. Only a few days back, there was a lady who was drinking and driving. She caused death. She's been charged with drinking and driving causing death. The murder 2 charge, Your Honor, has been added as an extra umbrella over to Travion. I'm asking the court to consider that it is he has been super punished, Your Honor. A fair sentence would be one which just punishes him for the one mistake he made that day in fleeing, but allows him to rehabilitate in the foreseeable future. Judge, foreseeable future, not the unforeseeable distant future. I thank Your Honor for the opportunity given to me to argue for my client. My client does have a few words of sorrow and regret to express to the Kinaya family, if he may.
Look, the facts remain, all right? He killed an innocent lady and her unborn child. Completely destroyed the whole family. That's why it's going to look like he's getting railroaded, man. Getting a max in every which way. Because pretty much what he did, accidental or not, is the worst thing you could do. But I'm really looking forward to seeing what the defendant has to say. Is he going to be apologetic? Or is he going to keep on acting like his facial expression, like he don't even need to be there?
The unforeseeable distant future. I thank Your Honor for the opportunity given to me to argue for my client. My client does have a few words of sorrow and regret to express to the Kinaya family, if he may.
Okay. Mr. Smith, what would you like to say?
First, I would like to send my deepest condolences to the Kinaya family. And I wish Faith Kinaya rest and live in peace. And I would also like to say something else. Your Honor, I respectfully move under MCR 6.431B for the court to review evidence related to the incident. I want to make sure my rights are, I want to ensure my rights are protected before sentencing, Your Honor. I have requested from my attorney, to file a motion to preserve my rights, and I respectfully request that this be my bad, Your Honor. I'm kind of nervous.
Listening to them damn jailhouse attorneys got him fumbling the ball in the courtroom, man. Look, if you were to ask me, this is a bad move. Even though he said his condolences first, it doesn't matter. To bring it up right before sentencing, man, it just doesn't look good. It looks like you care only about yourself. If you got an issue with something later on down the road, then like I said, you appeal it.
And I respectfully ask that this be noted on the record today. I also asked for a chance, Your Honor. I was 16 when this terrible accident occurred. I was scared, Your Honor, and I didn't understand what happened that day. I didn't commit any crimes, so I couldn't understand why this happened to me. I truly don't even understand why they followed me in the first place, Your Honor. I am not a murderer of any kind. The Lord knows my heart, Your Honor. And respectfully, with all due respect, I hope that He helps you to understand it as well. And with the evidence that I'm giving to you today, I pray that you can set aside my verdict, or you can give me a retrial. Please and thank you.
All right.
Just if I may, just a few things to follow up. First, with respect to, just to correct the record, counsel referenced the defendant's acknowledgement of testing positive for marijuana, and he says that later, after Mr. Caravallo came into the case, he indicated to the court he had worked late the night before, but in fact, the day that Your Honor revoked his bond, you asked his attorney, would he test positive, and the answer was yes. So, with all due respect to his work the night before, indicating that his marijuana use was untrue only means that apparently that attorney was given the wrong information by the defendant. Second, I appreciate counsel referencing fleeing and eluding. The defendant didn't intend to kill anyone, but that is why he was not charged with first-degree murder. He says that he is not a murderer. I have news for you, sir. You are. You are guilty of murder. Your conduct killed a woman and her unborn child. You are a murderer. Your Honor, the defendant wants you to protect his rights. He can't even make it through a statement to the family. He can't even express his condolences without immediately turning it to himself.
Yeah.
This is somebody who we don't have to worry about in the future? Well, I disagree. When we're talking about who we're looking at going forward, protection of the public, rehabilitation, he cannot even say, I'm sorry to the family without immediately citing the court rules and trying to indicate to the court that his rights need to be protected, which they are and they have been throughout the course of this. He has every right in the world to appeal, to argue for new motions. There is no issue with his rights.
And you know, I don't even think he said, I'm sorry. I think he said, my condolences. That's not typically what you would say if you're the one that ended the person's life. If you're to ask me, that's like what the people say that, you know, have nothing to do with the situation, but want to give a little bit of mental support, uplifting. I don't know, maybe I look at the word condolences a little bit different, but he should have said, I'm sorry from the bottom of my heart. I can't believe I did this, that, and the third. Not my condolences. I like to make sure that my retrial and everything's set in order. I got loopholes to jump around here, Your Honor. I'm only 16. I'm not a murderer. I was just scared of police. Come on, man. This guy's gonna get the Lamborghini smoke, isn't he, Bobby? But this is a horrible situation. You know, my heart kind of goes out to him at the same time because I was young, 16, doing stupid shit, running from police. I luckily just didn't kill nobody. Homeboy was just dealt a worse hand than I was. There's many situations where many of us probably could have ended up killing someone, driving in the car, right? So I'm looking at all perspectives, you know, and it's just a horrible situation. One thing for sure, though, when it comes down to this case is the defendant just doesn't look remorseful whatsoever.
And then finally, Judge, you know, when it comes to protection of the public, rehabilitation, the defense says people that flee and elude when they're a juvenile do not do so as an adult. Well, that I think we know in our experience in the courtroom every day, that's just not true. That he acted under anxiety. It was irrational. He reacts to these circumstances. Well, that tells me that the protection of the public needs protection from him, from his irrational behavior. The irrational behavior he's demonstrated throughout the course of his time on bond, according to the PSI.
Yep.
And most importantly, I think, is the defendant's counsel just referenced it could have been anyone. That's exactly right. It could have been a school bus full of children. It could have been anyone. It could have been no one if he just stopped. But instead, he's destroyed a family. He's destroyed lives, his own family's lives. But most importantly, the only victims in this courtroom are the family and the people within the car driven by Norman Lewin.
This is a great prosecutor. He took everything that the defense argued as to why he should get the minimum amount of time and twisted it as to why he should get the max. This is the perfect examples, Your Honor, on why he shouldn't be spared. And you can see the view from both sides, but if I were to guess, the prosecution is always going to be one level up because he's over there defending the helpless, right? The individual that lost their life. His side and perspective, if you were to ask me, will always look a little bit brighter.
Those are the victims here. He is not. He is not a victim. As much as he portrays himself to be or wants the court to believe himself, he is not a victim. He's a perpetrator. He is the one who committed these crimes. He is a murderer and should be sentenced as such.
Your Honor, one last thing. As far as apologizing to the family, condolences to the family, sympathy to the family, Your Honor, naturally I can speak on behalf of my client on all of that. And right at trial, when Faith's sister testified and I was allowed to cross-examine her, I told her, I don't have any questions for you. All I have to say is my deepest condolences and my sincere empathy to you and your family for the tragedy which occurred. And she accepted those condolences. Again, Your Honor, today I basically express mine and my client and his family's condolences to the family, knowing and acknowledging the tragedy has occurred. It's irreversible. If we could bring the dead back to life, we would, regardless of the cost. And Your Honor, he also basically mentioned that right at the beginning. Of course, he got caught up into the court rules, Your Honor. That was
neither here nor there, Your Honor. Let's look past it.
Extra, Your Honor. I acknowledge that. Based on all of that, Your Honor, I would still ask the court to consider the fact, as the prosecutor told the jury, the judge will consider at sentencing how young he is, how youthful he is, and he will take that into consideration. So, Your Honor, I will ask for that consideration to sentence at the low end of the guidelines, which are already super high, Judge. You further raise them.
All right. And Mr. Smith, I'll give you the last word. Do you wish to say anything else?
Yes, I do have something for you to read. As I recited this law, MCR 6.431B. I have my own timestamp that there was a video. I have the full video that was not shown in court, and I have everything written down for you. And my mother has it for you. She had received it from my lawyer. She received all my evidence from my lawyer.
All right, Judge. This is a juvenile brain. Okay, the court is aware of that. The court has seen not hundreds but thousands of juveniles in court. I would ask the court to take that into consideration.
All right.
Oh man, these guys are definitely not seeing eye to eye. Homeboy said, Your Honor, I apologize. This is a dumbass juvenile mind. He knows not what he speaks of. My apologies, Your Honor, once again. This is not looking good. Seems like the defendant does not like his attorney, not one bit. Don't think he's representing him to the fullest. That jailhouse attorney's plan worked. He wasn't trying to help him for real. He just wanted to see him get smoked.
After almost 30 years of practicing law, whether a criminal defense attorney, prosecutor, now judge for 14 years, I don't know if I've ever encountered a more tragic case than this.
Not good.
Mr. Smith, you said you're not a murderer of any kind. I mean, you could just, thinking of going back to that night, there's no drugs in the car. There's no guns in the car. You don't have any drug or alcohol on you. You don't even know that the car has no insurance. Okay? You would have been pulled over and ticketed for no insurance on your car. That's all. That's all. But instead, and I know you're 16 years old at the time. Okay? I know 16-year-old boys are dumb. But guess when that argument no longer goes anywhere. When you wipe out a family, you literally wipe out a family. That poor man Norman who is here, it's a fate worse than death. And all you had to do is stop. That's it. That's all you do. And it's always, and I see these, either it's drunk driving causing death or fleeing and looting that ends up. I mean, it never seems to, you're running into a semi truck where you wouldn't be here. No, you run into the family. You run into them. You kill the woman, her unborn child. The father literally cannot move.
Bobby Hewitt.
And the letters that were read by the victim's friends, I think were very nice. The victim in this family, one of the victims, her name is Faith. So, have mercy on your soul. Count 1, homicide, second degree. I'm going to follow the recommendation by probation. You're to be sentenced to 300 months to 600 months, 539 days served in the Michigan Department of Corrections. Don't have any contact with the family of Faith Kanaya. Crime victim assessment was $130. Court cost $600.
Smoke messing with his nasal passages a
$60
bit.
state fee. You must comply with DNA testing. Count 2, gross negligence against causing miscarriage, stillbirth. You are to be sentenced to Michigan Department of Corrections for 72 months to 180 months, 539 days. Credit. Again, $68 state costs. Count 3, reckless driving causing serious impairment of the body. Count 4, reckless driving causing serious impairment of the body. Again, 24 months to 60 months with 539 days served. $136 state costs. Count 5, fleeing and eluding. You are to be sentenced to 72 months to 180 months with 539 days
The smoke
served.
train just keeps rolling.
$60 state costs. They all run concurrent.
Well, there you have it, ladies and gentlemen. If I did my calculations correct, I believe it's a little over 25 years mandatory that he's got to do before he goes in front of the parole board. And keep in mind, if he gets denied in front of the parole board the first time for murders, he has to wait another 5 long years before he can see him again. I had no idea. I thought they could go back like the next year. Either way, hopefully some of y'all young bucks learned something from this one. It doesn't matter if you're out there racing, bobbing and weaving through traffic or running from police. You hit an innocent lady and kill her. Chances are, man, you're going to be in the same shower shoes as this guy with a one-way trip ticket to the penitentiary. I'm out of here, ladies and gentlemen. I'm still recuperating from my cold. I don't know if you can tell, but my voice is still a little raspy. It's time for me to go gargle some honey. But as always, until the next time, y'all be easy, be safe, and more importantly than anything, stay free.